The most important article of our 1215 Great Charter Constitution is Article 39 because it describes how the citizenry own the law through the conscience of the juror in trial by jury. So I'm just going to read Article 39 for clarity. No freeman shall be arrested or imprisoned or dispossessed of his freehold or his liberties or free customs, or be outlawed or exiled or in any manner harmed, nor will we, meaning the king or government, proceed against him, nor send anyone against him with force or arms, unless, according to the judgment/sentence of his peers and the law of the land. Now, Article 39 cannot be any clearer about how the people are the final arbiter of law through the jury. It effectively emplaces trial by jury twice by mentioning judicium parium suorum, the judgment and sentence of our peers, and legem terrae, meaning the law of the land, which is reference to the ancient customary framework of trial by jury. So it mentions it twice in the same sentence. I'm also going to confirm that with a quote by Sir Edward Coke from the case of Dr. Thomas Bonham v. the College of Physicians in 1610. Now, he confirms that the people are the final arbiter of law in this quote. And it goes as follows: the common law will control acts of Parliament and sometimes adjudge them to be utterly void. For, when an act of Parliament is against common right or reason, or repugnant or impossible to be performed, the common law will control it and adjudge such act to be void. Essentially, that's annulment by jury. It couldn't be any clearer. And by the way, this I am reading from Ken Dewdney's Democracy Defined. And I'm going to continue reading a little bit regarding that quote by Sir Edward Coke because it really hits some points home. So, in order for Parliament to have any law enforced, the absolute legal fact is that the law itself must be a legal law, and there is only one legitimate final supreme tribunal for judging, interpreting, and deciding the legitimacy of Parliaments and Congresses' statute laws. It is the common law trial by jury of peers. When Coke says the common law will control it, he is referring to the Constitution's controlling common law mechanism for declaring the legality of all law enforcement, judicium parium, judgment of peers. The explanation is provided by Coke's own words: the common law is declaratory of the principal grounds of the fundamental laws of England as inscribed into the Great Charter. Lawyers have only to learn and come to terms with the genuine common law constitution, as did Coke, to understand his ruling. It is after and only after the legitimacy and applicability of a statute have been judged on and approved by a unanimous jury following a legal trial by jury, that it is then legal for Parliament and government to utilise its supreme physical power and execute, enforce, the jury's judgment/sentence. There is really no dichotomy visible when the inquirer has first recognised that there is simply no other way than trial by jury for Parliament or Congress to enforce anything. However, it is only when the jury has decided the statute law is just and applicable in context for enforcement in any given trial that obviously the Parliament's law is given legal supreme authority by the jury and can then be enforced. So all power lies with the people through trial by jury. And we really need to hit this home to people. Because we've got people like Rupert Lowe at the minute talking about repealing certain acts, and there's no mention of the constitutional safeguard in place. There's no mention of trial by jury, annulment by jury. So the solution is there in plain sight, and it's being completely ignored, or there's nowhere near enough awareness of it, even within the legal profession. So it's up to us to educate the public of the supreme power of constitutional trial by jury and how the people are the final arbiter of law.